The first case we are going to look at is Nordt versus Nordt that was filed in the District Court of Appeals in Florida. The action was held that the District Court of Appeal held that the sanctions were warranted for the party and his attorney. The nature of the case was sanctions were warranted for the attorney and client whose appeal of non-final order compelling arbitration presented no justifiable question and was on its face devoid of merit. John Nordt filed a non-final order compelling arbitration for attorney's fees. The court found that it was frivolous, did not have merit, and accordingly, it was basically a non-issue. The issue in this appeal is whether the trial court erred by compelling arbitration between John Nordt and his former attorneys in the retainer agreement between Mr. Nordt and his attorney. It says any disputes relating to the quality of representation, fees and costs, or any other issues pertaining to our representation shall be arbitrated. Therefore, he filed for it to be a non-compelling arbitration. The court held that should have been a non-issue. It should not have even been brought. However, the court wasn't just upset over the frivolous of the claim, but that the attorney offered no apology, conceded no error, and boldly continued to profess the correction of his position. So it wasn't just that he filed a frivolous claim with no merit. We will now look at the Tennessee rule that coincides, and it says that it should be filed with good faith, or represented with good faith and basis of law and fact for doing so is not frivolous. A lawyer for a defendant or a respondent could result in court may nonetheless so defend the proceeding as to require that every element of the case is established if the attorney is representing the defendant. The advocate has a duty to use legal procedure for the fullest benefit of the client's cause, not to abuse the legal procedure. It establishes limits. So I am in agreement with the sanctions that were imposed and that it was frivolous and without merit. It should have been a non-issue. The retainer agreement clearly says that it will go into arbitration, and it went on to say, and the attorney left out this part of the agreement, the retainer agreement, that says that it will be arbitrated in a matrimonial attorney by a matrimonial attorney from Miami-Dade County, certified by the American Academy as an arbitrator. This agreement contains provisions and fee disputes. I am in agreement with the ruling of the court.